But what I'm going to do is go on to Ostley, and I want to show you how you can look up legislation and relevant information on the website. And I'll just take you step by step through it, and it's a very useful site on how you can find information, and you'll be able to use that in the course of this subject. What I want to do as we do that is we'll also have a look at conflicts of interest, and I'm going to show you some of the legislation in relation to that, and we've got some notes in our learning materials on this as well. And I'm just going to also show you a case which dealt with a conflict of interest which relates to conveyancing, and you can have a little look at that. And we can also do a search of the AXA Code of Conduct, which has a number of sections which looks at the industry association's approach to some relevant areas which in conveyancing. The last thing which we'll do tonight is the business contract exercise. Now, the last couple of weeks, I can see you all, you're now business experts. You've gone through a lot of the business stuff, which was great. And last time, you should have been given copies of, blank copies of the contracts. And what I'm going to do is give you an exercise where you'll actually fill out the business contract, okay? And we'll do part of that while you're here with me now. And then perhaps you probably will have to finish it off at home, but that's fine. Now, next time, just before we do start, over the holidays, I think your first assignment is due, okay? So please read the questions very carefully. Many of them are short answers, and try and, where relevant, where you've got an answer, support your answer with the sections of the Act that are relevant, okay? So whatever your statement is, support with a section of the Act to support what you're saying. Now, the next session next time, okay, which is the first week back after the holidays, what I will be doing is we'll have a look at the RESA residential contract, and then what I will be getting you to do is to start a second exercise where you'll actually fill out a contract for the sale of land and a Form 1 again, okay? So I'm mindful of the fact that I think your assignment is due the second Wednesday of the school holidays, from memory, okay? 9th. Yeah, 9th of October. So what you might want to do I know you'll be raring to go after you've done that assignment, and you'll be full of enthusiasm, but what I might suggest you do is do the first case study blind again, okay? So do it start from scratch, try and do it again blind, as if it's a new exercise, so that by the time we come to the next session, you'll be ready and raring to go to do the second exercise, filling out the contract for the sale of land and the Form 1. All right.
Okay, so what are we doing first? The assessment that's due
You've got to do the assessment on the 9th, absolutely, okay? But I know how enthusiastic you're going to be after you've done that assessment, so you'll have a week until we have our next lecture. So what I'm suggesting you do is, just for practice, is do the first exercise, filling out the contract for the sale of land and the Form 1 again, blind, from the beginning, all right? So that it's practice for you.
Bill,
yeah.
In our resource, we've got a Form 1 ASA contract, but it's not blank, it's pre-populated with ticks on all the items of particulars. So how can we use that as a practice when it's pre-populated?
There's a word processing version.
Yeah, I understand that.
Yeah.
But if we want to use this form, which we'll often be using anyway in reality, because this is much easier to follow and to fill out because it's so much better formatted, we can't because it's pre-populated. Do you see?
Yeah.
It's got all ticks. I just only printed out a few pages, all ticks in all the tables of particulars if you turn over.
Right. Yeah, well,
can you give us a version that's not pre-populated with ticks?
Well, just when you print it off, just scratch it out. It's not for marking. It's just for your practice.
Yeah, I know
that's
that.
all.
But still, can't we get a copy that's not pre-populated with ticks?
I'll have to have a look at it, but I don't think so. But I'll see if there's something I can do with it. But at the end of the day, this is just for your practice. Okay. So if you print it off, cross out the tick and tick it if it's relevant. All right. But the word processing, the word one on the site, you can use that as well. Okay. And in the exam, you'll get a copy of the Word version of the Form 1 on there. All right. Okay.
Can we get a copy too of the Form 2 AXA, because we haven't got that?
You've got that on the side.
We've got Word, but not AXA.
No, I haven't got. I don't think I've got the AXA one. So No, you don't need the Form 2 on there. You're not going to be doing an exam on the Form 2. It's a Form 1 that you're going to be completing.
So it'll be Form 1 plus the initial...
Contract. Yeah. Yes, okay. So just to reaffirm, you're going to be doing a contract for the sale of land, a Form 1, and a business contract in the exam.
But not a Form 2.
Not a Form 2, no.
Yeah.
Just a Form 1. Okay? All right. Now, so let's have a look at the first thing which I want to take through to tonight. And, oops, excuse me. Now, just out of interest, how many of you have used Ostley before? About half of you. Yeah, half of you. I've used the Ostley website before. No, okay, half. Okay, that's good. Now, what I'm not doing mine. Just bear with me a moment. I want you to be able to see this, otherwise I'm just talking. You're not going to be able to see anything.
Do you link to one of the...
Okay. Now, the Ostley site is very useful, okay, when you go on there, and on tonight's outline you'll be able to see a link to the Ostley site. And when you go onto it, you'll be able to see there's lots of different jurisdictions. Okay? So to give you a very simple example so far today, we've got lots of jurisdictions here across the top, Commonwealth, the different states, and we've got South Australia. Okay? So if we click on South Australia, and then you'll see the resources we've got for South Australia, and we'll see we've got case law and we've got legislation. Okay? Now, we're going to have a look at legislation for the moment, and it gives us a few options. You'll see points in time, numbered acts and so on, but the easiest and the best one for us to look at are the South Australian Current Acts. Okay? South Australian Current Acts. Now, if we have a look at... we want to have a look at the Land and Business Sale and Conveyancing Act. Okay. Then we can actually the easiest way is to click on the L, and then we get a list of acts there in relation to beginning with L. And we can simply click on the Land and Business Sale and Conveyancing Act. Okay.
So you've got the all SA case law, SA legislation and other SA materials.
Yeah, we're looking at legislation for the moment. Okay, so if we now look at the screen, you'll see we've got the Land and Business Sale and Conveyancing Act. And that sets out all of the sections. Okay. Now, what's also quite useful, okay, if we follow down, is if we look at, this varies in different jurisdictions, but we're quite lucky in South Australia because we have a section here like on legislative history. So if we click on that, we can actually then follow it down. It gives us the Principal Act and amendments. Okay, so we can, for example, find out when the Act was last amended. And you'll see here the last amendment going down is Act number 30 of 2017 and a Beneficial Interest Amendment Act. So that Act passed in 2017, amended our Principal Act. So we can see that that's the latest Act. So when we're checking to see for an Act to see if there have been any updates, it's very nice and easy to do that. And it also will show different sections and when they were amended if we need to actually go down that path. So that's one act that we can look at, and we're going to come back to that in a moment. What I also want to do, well actually let's have a quick look. We're going to talk about conflicts of interest tonight. So we can have a look at Section 30 of the Land and Business Sale and Conveyancing Act. Okay? And you'll see that what we've got here, the Act specifically says, conveyancers are not to act for both parties unless authorised by regulations. Except as authorised under regulations, a conveyancer must not act for both the transferor and transferee or the grantor and grantee of property rights under a transaction. Maximum penalty, $20,000. So the starting off point is we can't act for both parties, but it is subject to regulations. Okay? Now, when we talk about Acts of Parliament, okay, what we need to understand is the Act of Parliament will generally talk very generally. Okay, so it will set out, what the Act is trying to achieve, and have a number of sections detailing what the Act is about. But the procedural aspects of the Act, what I often call the nitty-gritty, okay, the things that actually put the Act into place, will normally be found in the regulations. For example, okay, we've already talked about, and you probably are very familiar already, Section 7 of the Act, okay, basically says that particulars have to be supplied to the purchaser of land before settlement, okay, largely in relation to the vendor's statement. Now, it doesn't actually detail that information, okay? It just says a statement in the form required by regulations signed by the vendor, setting out all of those details. Now, we now need to have a look at the regulations. So if we go back to legislation for South Australia, I'm just actually hitting the back button as we do this. So we're going back to legislation for South Australia again, clicking on the SA tab. All right. Now, with the Act, we looked at current Acts. Now we're simply going to look at current regulations. And we can do exactly the same thing again. Click on L for land and business and sale. And we'll see here we've got land and business sale and regulations. You still awake on me? Just about? Yeah? Yeah? Okay. Now, you'll see on here, all right, we've got part 1, part 2. And we can actually go down to the miscellaneous, going down to section 32, and we've got the keeping of records. And for example here, we've got Schedule 1, contract for the sale of land or business. Okay. And lo and behold, what do we have here? The Form 1. Okay, so that's set out in the regulations. Now, all of the industry examples of the Form 1 have to conform with this example. Okay, they have to contain exactly the same thing. They usually will have their little motif on the top, but they have to comply. So the Form 1 is here, and if you go down, you'll also find later on, I'm going down very quickly here, we should be able to find the Form 2. Form 2, there we go. All right. So they're all set out in the regulations. Now, going back up again, and we're going to come back to some of the regulations themselves again now. And if we have a look at, lo and behold, we talked about conflicts of interest. Okay, I remember a few moments ago we said Section 30 said that we couldn't act for both parties, significant offence, but subject to the regulations. And now we've got Part 3, dual representation, Section 29. You have been bacon. Now, in our notes we've got some information on this as well, but I thought while we've got Ostley out, we may as well have a look at this as well. Okay. And you'll see we've got here, Section 29, circumstances in which a conveyancer may act for both parties. Okay. So, for the purposes of section, well, actually, do you know what we're going to do? Before we do this, we're talking about conflict of interest, so I'm going to go back and let's have look at the definition of meaning of a conflict of interest. Okay. So, we've got, for purposes of this part, the conveyancer is subject to a conflict of interest in relation to a transaction if, the duties owed by the conveyancer to one party to the transaction conflict with the duties owed by the conveyancer to the other party to the transaction. For example, if the conveyancer is obliged in fulfilling his or her duty to one party to withhold information or advice from the other party that by reason of the conveyancer's duty to the other party he or she should not withhold. Okay? So the best way to explain this is kind of divided loyalties. Okay? If you're acting for both people, and I've got a duty to you, Julie, and you're in a contract, in a transaction with you, Martha, if I can't advise you properly because the advice I give you would be contrary to what your position is, Martha, or vice versa, then we may have a conflict. Okay? And this can be a problem. The problem with this area, and we'll have a look in the notes that give some more examples, but the problem in this area is that sometimes you don't see it coming. You don't expect this is going to happen because everything's rosy and everything's good. And then later on down the track something arises and suddenly, oh, hold on a minute, I'm in trouble here. I may have to cease to act, and it becomes very messy. And most of the professional bodies, their attitude is that don't act for both parties. But we'll come back to that for a moment. Now, the second one here is if the conveyancer has a personal or pecuniary interest in the transaction arising other than from the conveyancer's services as a conveyancer in respect of the transaction. Okay? So if you, as the conveyancer, have some type of interest in the property sale as well, that which that itself could be a conflict of interest, and we'll come back to that a little bit later. So we've got a good example.
If you're going to buy a block of land or whatever, you don't conveyance for yourself.
Well, what it's really saying there is that usually this will hit you in the sense that you may, for example, you might be a part owner of a property, or you might be a shareholder in the owner of a property. And so quite often that's where people can get caught. So the next one we've got, so let's go back to section 29, or regulation 29 I should say. That's okay. Now, for the purposes of section 30 of the Act, a conveyancer is authorised to act for both the transferor and transferee, or the grantor and grantee of property or rights under a transaction if the transferor and transferee, or the grantor and grantee, as referred to as both parties, are related to one another by blood, adoption or marriage. Okay? So you can work for both people in those situations. Are domestic partners one of the other? Are bodies corporate that are related to each other? Are proprietary companies and a person who is a shareholder or director of the company? Or are registered as the proprietors of the relevant land as tenants in common, or joint tenants with one another, or carry on business in partnership with each other? Okay, so if those situations, if the parties involved in the transaction fall within those situations, then you can act for them. Okay, but note here we've got or. Okay, or. B, the conveyancer has obtained from both parties a written acknowledgement or general authority in the form set out in Schedule 9. Okay, Schedule 9. So we're going to come back to that in a moment. So essentially, those sections above, if the parties are in those type of relationships, you can act for both of them. Otherwise, B could come into play. You've obtained a consent acknowledgement from both parties in the form in Schedule 9. We'll look at that in a moment. 2, however, a conveyancer is not authorised to act for both parties to a transaction if the conveyancer is subject to a conflict of interest in relation to the transaction. Okay? So if the conveyancer themselves have an interest in the property, okay, and I've got a really good example for you in a moment we'll look at, then we can't do it regardless of that. Now, let's come back to section 30. And if a conflict of interest does arise, if the course of acting for both parties to a transaction, the conveyancer becomes subject to a conflict of interest in relation to the transaction, the conveyancer must notify both parties in writing and cease to act in the matter. Okay? penalty £5,000 otherwise. However, if both parties agree in writing that the conveyancer may continue to act for one of them, the conveyancer may continue to act for that party. Okay. So there is a proviso there. Now, we just have a look at the schedule here. Again, we're still into the regulations. Okay, and that regulation is referred as to Schedule 9, wasn't it? And if we then go to the bottom of the regulations here, we'll see Regulation 9. And we've got the acknowledgement that a conveyance acts for more than one party. There, form there. And that's a very specific one, usually for a single transaction. And Form 2, a general authority to the conveyancer to act for more than one party. So if the parties don't fall within those exceptions, but you still want to act for them, then you'd need to fill out one of these forms. Okay, the subtenses, yes. Yes, yeah, that's right. Yeah, I'm just trying to show you how you find this on the website. Now, also on here, now we've looked at a bit of legislation here. Okay, I'll try not to send you to sleep too much on this one. I'm just going back now. So we're going back to the beginning of the website, and so we're going back to South Australia. But now we're going to look at the case law, okay? And you'll see on there we've got different court areas, Supreme Court and full courts, and different options there. And I think I should be able to just put in here, do a little search in the top right-hand corner. And what I'm going to do is just do a search on a case that's I'm going to get you guys to have a little bit of a look at. Commissioner for Consumer Affairs versus Flood. And there we go. We've got the case from 2010. It comes up, and we can just click on that. And then we've got a case which you can actually read and have a look at. This case is on point for what we're looking at tonight. It's not, a great big, involving major events, but it does show how most experienced people can come a cropper with this area. Have a quick read of this. Julie, it is there. When you go on to
Because I had a look just before I got here.
case studies land, when you go on to there.
Yeah, but when I clicked on that, that's the first one. I'm talking about the second one.
Oh, the second one, we haven't done that yet.
See, that's what I was asking about, the second one.
Yeah, no, that won't be available later. You're going to be doing that exercise in the next lesson.
Did you give us the searches for that one?
No, I haven't given them to you, no. But they're here.
Okay, because that's what I wasn't sure of whether or not we'd got the searches for that one and whether he handed out the answer to that last week.
No,
he didn't.
It was for this one, first case study one. All case study one. Okay. All right, you can talk to me about that afterwards.
Okay, cool.
Yep.
Yeah, no, that's fine. So when we can do that, I'll say next time back.
Next time back. Yes, next time. Okay. Now, just let's have a look at some of the regulations here again, and let's have a look at Regulation 29. Okay. Regulation 29, and that section details the circumstances in which a conveyancer may act for both parties, and we have those situations. In subsection 1, we've got a number of examples where conveyancers can act for both parties. For example, our domestic partners of one or the other. The alternative is under subsection 1 or B, is that the relevant forms can be filled out and can be signed as acknowledgement. And number 2 says what? Subsection 2 of Regulation 29 says what?
However, conveyancer is not authorised to act for both parties to a transaction if the conveyancer is subject to conflict of interest in relation to the transaction.
Good. So if the conveyance is subject to a conflict of interest in relation to the transaction. Now, with Mr. Flood, I mean, he was basically buying residential and properties himself, wasn't he? He was part of a side business. And his conflict of interest was essentially he was a director or shareholder in one of the companies, so then on 3 occasions that were purchasing properties. And under the regulations here, clearly that was not allowed. Okay, and if we go to subsection 31, okay, Regulation 31, I should say, and we've got the meaning of conflict of interest, okay, and we've got the longer definition at subsection A, which we talked about, and under B we've got the conveyancer has a personal or pecuniary interest in the transaction arising otherwise than from the conveyancing services as a conveyancer in respect of the transaction. Okay, so again with that, the conflict of interest, and that's why the conveyancer in this situation came at a little bit of a cropper. And if we just go, it's not the most riveting thing to read, but I'm just going to, if we actually look at, I think I have page 12. And I think what's also interesting is to write. Just bear with me just a moment. I think the conveyancer was fined $2,000. Page 12 of 13.
Fine of $2,000.
Yeah. In addition to it, I impose a fine of $2,000 in relation to that. And at point number 59, the judge did say, I accept that Mr. Flood is a person of otherwise good character, that he regrets his behaviour and is unlikely to reoffend, and that these proceedings have no doubt caused him some embarrassment in a small community. And in many respects, the embarrassment to the guy, was probably more significant than this issue. Okay, because professional embarrassment in the small community that he'd made this mistake, basically. All right, and this. Okay, so that's really quite a useful little case to have a look at that. Just going to your learning notes now. Okay.
So, Bill, they were considering suspending his or cancelling his registration as well? Is that
No, I'm pretty sure that was not. He was just reprimanded, okay. And it was up to then if disciplinary proceedings could be brought. That's a separate thing. Yes, yeah. There was a land agent who actually involved in that. He was actually a criminal action was brought against him as part of in this particular case in the land agent's role in that, and he went to court and was fined quite significantly more. But there's a distinction between a criminal offence and basically disciplinary proceedings, because the idea behind disciplinary proceedings is that it's to protect the profession and the public rather than to punish the individual, if that makes sense. That's for the courts and the criminal area to do, if it necessitates that. But it was a fine of $2,000 as part of this process. Yeah.
I think it's just a mention there before at paragraph 17. This is a considered suspension of cancellation more than is required for the ongoing protection of the public. But that's not the.
Would be more than is required. That's right. Would be more than is required for the ongoing protection of the public. So he wasn't going to suspend that there.
Yeah, the
but-
court hasn't got the jurisdiction to do that
Uh,
anyway. That's
well-
up to the commissioner, isn't it?
Well, the commissioner could bring for disciplinary proceedings
Yeah,
as
that's-
part of
yeah.
But under the, we'd have to look at section 45 of the Conveyances Act. You might be interested in looking at that. I think it's section 45 off the top of my head.
Yeah.
Okay.
Would even a reprimand make insurance proceedings go up?
Well, that's a very good question. Yeah, I would suspect yes. The other issue here also, which is, I'm glad you've raised that, is that when it comes to conflicts of interest, there's usually a much higher excess which parties will have to pay due to the conflict of interest situation. So that's a double whammy really as far as the insurance is concerned in relation to that. Okay, now just looking at your learning material notes here, just to, we've got much of what we've just discussed. I'll start on page 30. And page 30, it talks about the basic principle: a person in fiduciary positions such as real estate agents, conveyancers, can't properly serve the interest of more than one party. Okay, and page 30 talks about how the industry says no, don't act for both parties. And page 31 and 32 looks at what we've just really looked at on Ostley, and as does page 33, which has got the forms, the two forms there. On page 34, we've got again the definition of what is a conflict of interest from Regulation 31, and then it gives us some examples here at the bottom of page 34. Okay. And I'll just read this out for you. There are many situations which a conflict may arise, especially because the conveyance often receives confidential information or advice from a party that because of their duty to the other party they should not withhold. The information might be of advantage to one party but disadvantage the other. So if you're acting for two people and, for example, you've got confidential information that you know from one that could affect the other party, you've then got an example of a conflict. So, for example, where a private contract where the information could relate to financial pressures on one party, the urgency to move in or out, marriage breakups, etc. The information could be received at any time before settlement and might seem insignificant at the time, but significant later. Now, then we've got examples of conflict that a conveyancer should advise their client are disputes over the construction or interpretation of a contract. All right. What does this clause mean? Example: default interest, breaching the contract, possible misrepresentation by a vendor or their agent, a defective Form 1, okay, which could have implications in the transaction, obviously, termination, calling off, so advice that has been given. You could also have another good example, I think, is where you might have a buyer wants to takes possession early. There may be some settlement issue, settlement has been delayed, and the buyer wants to take possession before the settlement date. And in a situation like that, the conveyancer would be unable to advise the seller that this arrangement is not in their best interest. You'd never be allowing a purchaser, in my view anyway, to actually to move in before the settlement. Okay, and they do licences to occupy and things like this, but from my mind, it's bad practice. All right, and if you're working for both parties, you'd be unable to advise the seller that this arrangement is not in their best interest, because the buyer's best interest is also involved, and you've got to represent them too. And the problem then, you've got pressures, all the purchaser who you might be acting for, all the settlement has got through, I've sold my house, I've got nowhere to go, etc., etc. But, in my view, you don't want to give, before the settlement occurs, you don't want to give a buyer possession of the property before settlement, because what potentially could happen? I'm talking worst case scenario here, I might add, but what potentially could happen? Falls through. That's right. Finances turned down, absolutely, and you might have. I don't want. I don't want to make this, start getting you all panicking and worrying, but you could have one of those professional fraudsters, I think worst case scenario, that yep, okay, well, I've got possession now, I'm not going to go through the settlement, I'm cancelling settlement, I'm staying in here.
Squatters' rights.
Squatters, I'm staying as a squatter. And then don't get me wrong, you're going to, it's going to take 6 months or whatever it is then to get them out. You see what I mean? So until my view on that is until you see the colour of their money and the transaction's gone through, you're not moving in, buddy.
Yeah.
But, again, this is like, you can't advise that when you're acting for both. Okay. And you'll see the professional bodies have their views on this. They don't want you to act for both parties. But, in some situations, the risk may be a lot lower, and you can see with some of those exceptions they've given. What we'll also have a quick look at here is, just bear with me a moment, if I can just work out bookmarks, other bookmarks. Let's have a look at the AXA Code of Conduct. Okay, the Australian Institute of Conveyancers. You can do a Google search and get that up, and you'll see the Code of Conduct which applies to members of the Australian Institute of Conveyancers, and there is a section here on...
You've got that on the Learn, haven't you, Bill?
It's on Learn, I think, yeah.
That's right.
And I think...
Just gone through all that with finance.
Good. Well, just so you can actually see it, and off the top, let's have a quick... so let's have a look at... we should have conflicts of interest in here somewhere, and I'm having a brain problem.
Control F, write it.
Where it is. My computer... it does deal with conflicts of interest. I'm just trying to see if I can find it. Okay. Okay. 11.4. Okay. A conveyancer does not act for more than one party to a transaction except as permitted by the Acts, which you're now experts on. Where a conveyancer acts for more than one party to a transaction and a conflict of interest arises, the conveyancer must cease to act for any party in transaction except as permitted by the Act. A conveyancer acting for more than one party to a transaction must treat all of their clients equally. So it's following very much the principles of the Act there. All right. Okay.
So if a conflict occurs and you have to stop acting, now it's been a while since we filled out those transfer documents and everything, so I can't remember fully, but I imagine if you've already put in transfer documents or documents you've already lodged, what happens with that then? You just freeze, you have to cancel it, or you just freeze everything and the new person...
Well, they're saying that they've already been lodged, you're saying, so they're already in the system, aren't they?
Yeah.
But
not executed yet.
Okay. Well, if you're going to stop, you've got to stop. But if they've already been lodged, then that's another matter. That's out of your hands, isn't it? But at that side, at the moment you've got the conflict, then according to the regulations, you've got to cease to act. And that's one of the issues, you see, is that the problem is that if later on, something like this happens and it gets complicated, and then there's going to be lots of expense because the parties may have to engage somebody else who's got to start from scratch. There may be issues that may have cropped up which have caused delays and so on and so forth. So it's exactly.
Who pays for that?
Well,
or is it a loss?
Well, it's a loss, isn't it? And that's, you might see initially, this is the problem, it's like, initially, a lot of people do, act for both because of the cost saving in the beginning, and you think, well, everything's honky-dory and there's no problem, but if it does happen later, the costs can actually be much bigger because, whatever problems may have been occurred. I mean, you haven't got the crystal ball, so unless it's, fairly straightforward. Many places have policies that they don't act for both.
Just don't.
That's
there is always that risk.
And that's the issue.
in their
Yeah.
situation, unless
But-
those...
But what you will find, though, in many cases, is that many conveyancers, particularly on those, you know, those exceptions on,
domestic partners.
yes, under Regulation 29, the ones that are listed, quite often you'll find that many conveyancers will do those because they see them as lower risk.
Yeah.
All right? But, you know, the classic, you know, many situations like family law matters, you know, when parties, you know, the parties may come into your office, oh yeah, we love each other still, everything's fine, and, you know, blah, 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 everything's good, we've got no disputes, rah, we still love each other, etc., etc. And you know, you then do both of them, and then 2 weeks later or a month later, you know, it's the nuclear bomb goes off, and these lovers no longer lovers. If you get my drift.
Knives instead.
Exactly, and then, you know, then you've got the problems. All right. Okay.
Yeah, Gemma told us we shouldn't do that unless they have a binding financial agreement.
Exactly. Yeah, binding financial agreements under the Family Law Act, and that's you know, I'm always wary of family law situations because they can turn. Oh, you're letting me down, Julie.